Good morning, fathers and daughters. This is FRB Martin, and welcome to another live stream at Grow Dad YouTube channel. Yes, we have another live stream today, folks. Fathers, welcome. To all my Spanish speakers, bienvenidos, mi amigos, aquí, hoy. Okay, fathers, welcome, regardless of your ethnic group, background, and or culture. I welcome all fathers. Okay, fathers, we have a great live stream today. What we're going to be talking about today, fathers, is emancipation of minors. Okay, so the reason I want to discuss the emancipation of minors is because at one point in my career, I was the state of Colorado juvenile probation officer, and I actually have minors that were on probation that became emancipated from their parents. And I think it's an important topic. It doesn't happen a lot, but I just want to share this information with you and let you know the possibilities of if a child gets to a point where they are trying to get emancipated from their parents, there's a process that's involved, okay? Now, I'm not suggesting it by any shape or form, but what I am going to do is I'm going to discuss it and I'm going to talk about it in my career as the state of Colorado juvenile probation officer with the 1st Judicial District, Jefferson County, Colorado, state of Colorado. I had, in the almost 10 years I was a probation officer, I had about 5 children that were a part of the juvenile justice system, the criminal justice system. They got emancipated from their parents, right? Now, emancipation can happen whether a child is involved in the criminal justice system or not. But my experience of children becoming emancipated happened while they were on juvenile probation, okay? In the circumstances, all of my kids were 16 that became emancipated from their parents. There were a lot of circumstances that were involved, okay? Them being on probation was one thing. Now, even though they became emancipated at 16, I still kept them on probation until they were like 17 because it was a transition. And the courts don't take it too lightly to emancipate a child from their parents. And the reason that the courts don't take it lightly is because pretty much the child is in independent living. They are transitioning from their parents into independent living to live on their own. But there's a criteria they have to meet. They have to be able to take care of themselves. Financially, they have to be able to pay their own bills. Their parents are still covering them because they're still minors while they're on insurance, or they may end up on Medicaid through the state in which they're seeking emancipation. My experience of working with most children that were emancipated from their parents came through the courts. And it was a very difficult process. It wasn't easy. It took each one of my children that applied for emancipation, it took about 6 months to a year before the court decided that was going to be in their best interests. It was better for them to be in their own and independent living versus living with their parents. So, like I said, my kids, none of my kids that eventually got emancipated from their parents, while I had them on probation, none of them had drug charges. None of them were on probation for drugs and as their main charge. Some of them just did not get along with their parents, and it had been years. It wasn't something where they were 14 and 15 and then came to the court being on probation saying, "Hey, I want to get away from my parents." There's a history of the criminal justice system being involved. Matter of fact, 4 out of 5 of the kids that I can remember, they had been placed in the foster care system. And I would have to say the majority of the kids that end up getting emancipated, most of them come through the foster care system. And they've probably been placed at 5 to 10 different group homes, foster care placements. And by that time, after being a part of the foster care system for, a decade or so, they were looking at getting out on their own. They wanted to be out of the criminal justice system, and they wanted to transition into regular society. So it made a lot of sense for my kids. I supported them on that. We had a extensive transitioning plan for them to go to independent living. I had to file with the court documentation on why I supported it, and their caseworkers, because they all had caseworkers at the county level through the Department of Human Services that wrote their case plans up for the transition. Now, like I said, I kept them on probation. So it was just a check and balances type of thing. And for a lot of these young people, they still need that because they're going to need that year to be able to prove to the court that they can transition on their own and be a part of independent living. They're not required to work full time, but all of my kids, they did work full time. They did go to school. They finished school, right? They were 16. So most of them were either going to get their GED or they were finishing school at 16 years of age. Most kids that I supervised that were a part of the foster care system, it was better for them. And they decided that they want to get their GED, which is actually hard. The GED is very difficult to get because when you take the tests, it's on all of your subject matter. So if you haven't been to school for quite some time, it's not as easy as it appears to be. So I respected the kids and their decisions for wanting to get their GEDs and to go into independent living through emancipation. So they had my full support. I advocated for them in court, had to convince the judges that it was in their best interest, as well as their caseworkers. Okay, so fathers, I just want to take a look at that today. I have some great videos that I want to share with you. The first 3 to 4 videos I'm going to share with you are back to back, and it's talking and explaining the process of emancipation of minors from their parents, what it looks like, how it can happen, what's involved. Okay, so it won't happen probably in your lifetime, but it's just good information, I believe, to have. Grow That YouTube channel is all about education through instruction. Okay, information that we share on Grow That YouTube channel is all fair use, right? So this is what I'm going to do today, fathers, and I welcome you all. Hope you had a great weekend, fathers, and let's get busy with these videos talking about emancipation of minors. Okay, first video, fathers. Let me get it set up.
Many young people in the foster care system ask, is it possible to exit foster care before turning 18? And it is. Highly independent and responsible youth can file for emancipation with the court. Age and requirements for emancipation vary state by state. In Montana, someone must be 16 years of age and able to support themselves in order to be eligible for emancipation. There are many benefits and challenges to consider with emancipation. Here are a few that you should know. So one of the pros is that any money that you earn is yours, and your parents or the state have no ability to interfere with it. You can purchase and rent your own home. You can apply for Medicaid and have autonomy in making your own medical decisions. You also can apply for public assistance and get a driver's license without this, without the permission of the state or a parent. Although there are many benefits to consider and it makes emancipation sound pretty good, there are also many downfalls to emancipation as well, including that you lose all financial help, sometimes including your health insurance. Medical costs will be your responsibility, and also your caseworker, parents, and foster parents will have no obligation to financially support you or provide you with food, clothing, or anything like that. Also, some college scholarships require that a person aged out in order to be eligible for that financial aid. And lastly, emancipation is a very long and trying process, often lasting 4 to 6 months at least. So these are all important things to consider when thinking about emancipation. I encourage you to make your own pros and cons list. What do you have to gain through emancipation? What do you have to lose? And Also, it's important to consider, are there any ways that you could gain more independence and autonomy without emancipation? Talk to your foster parents, your caseworker, and see if there's other options aside from emancipation to getting the independence that you are craving.
For How do I become an emancipated minor? An emancipated minor is a person under the legal age of adulthood that gains full legal independence from his or her parents or guardians. In most places, a person can only be an emancipated minor under specific conditions, such as marriage, financial independence, or military service. Becoming an emancipated minor is a big step that requires careful consideration, but most regions do have a legal process for achieving this goal. Financial independence is the key to becoming an emancipated minor for many people. To get emancipation on this ground, the minor must be able to show that he or she has legal, documented income or resources that will cover basic necessities, such as rent, food, and medical care. In some jurisdictions, a minor can only apply for emancipation based on financial independence if he or she is already permanently living away from home and surviving on an earned income. While it is sometimes possible to financially survive without assistance as a teenager, it is important to know that emancipation does not supersede child labor laws, and there may be restrictions on how many hours a teenager can work. In some regions, a minor can achieve emancipation if he or she marries before reaching the age of adulthood. Depending on the regional laws, marriage before age 18 can require parent or guardian permission, or even a court order. Getting married solely to achieve emancipation can be a very risky proposition, and may even be considered fraudulent in some places. Only if a minor truly wants to have a permanent marriage and is able to financially survive with his or her spouse should this option be considered. With parental and official consent, a person can achieve emancipation by joining the military. Joining the military is a binding contract that can affect career, education, and life choices for many years, so it is not a decision to be made lightly. In order to join the military before adulthood, a signed waiver from parents or guardians is required. Forging a waiver signature may be grounds for disciplinary action, dismissal, or even criminal charges. In most places, a person becomes an emancipated minor by filing a legal petition for emancipation. These can be found at local courthouses, and may require a filing fee. Legal experts warn that while it is possible to file a request for a fee waiver, it is possible that the court will take a waiver request as a sign that a teen is not financially independent. If possible, consider visiting a free legal aid clinic or hiring a lawyer to help with emancipation paperwork. After the paperwork is filed, a judge will set a hearing date if he or she thinks there is grounds for the case. At the hearing, both the parents and the minor can present evidence for or against emancipation. The judge will make a decision based on this evidence, which will serve as a final judgment to allow or not allow emancipation. Minors who are being abused by their parents may want to consider alerting Child Protective Services or the police as well as filing for emancipation. Physical or sexual abuse and neglect are criminal actions in most places, and a judge may very well consider any criminal reports of abuse when making an emancipation decision. In addition, reporting abuse can open the door to other viable options for those that are not financially independent, such as transferring guardianship to a trustworthy relative.
Hi, Sarah Jacobs here. Today we're talking about a hot topic between divorcing parents, and that's the question of emancipation. I know, we all have children and we all love them and we all want to support them emotionally and financially well into adulthood and probably beyond. But divorcing parents are particularly sensitive to the issue of emancipation because it means freedom from financial obligations that you either agreed to or the court has imposed. So what does the word emancipation mean? In lawyer lingo, it means the time when your child is outside your sphere of influence. There's no magic cutoff age in New Jersey for this, and it's more dependent on factual circumstances. It's true that the law changed several years ago to presumptively end child support obligation when a child reaches the age of 19, but that's not the magic rule. It depends on a lot of different factual circumstances, and as you might have expected, there are exemptions to that bright line rule. They include higher education, disability, and a lot of other fact-sensitive circumstances. If it's not a magical age, then how can a parent know when a child is emancipated? Sometimes the factual circumstances are clear. If you don't go to higher education, or if you get a full-time job, clear. If you get married, if you join the military, again, clear. But sometimes there are circumstances where things are left a little fuzzy. What happens if your child has a gap year between graduating high school and going to college? What happens if your child is in college and takes a medical leave? Are they then emancipated? These are the circumstances where working with an experienced attorney who understands the nuances in the law is key. Just like there's no magic age, there's also no magic wand waved to create emancipation. If you haven't clearly defined in your settlement agreement or the court hasn't defined for you when your child is emancipated, stopping child support or other forms of financial support can be tricky. If you haven't defined it in your agreement or you're still working through the process and trying to figure out those trigger events, you have a few options. One option is you can agree with your co-parent about when your child is emancipated. If they've graduated college, maybe it's the month following. If they're living with you but working full-time, maybe it's 3 months following graduation. Whatever you and your co-parent can agree upon, a skilled lawyer or lawyers can help include that in a settlement agreement or a post-judgment consent order. When those documents are filed with the court, and assuming nothing's changed, you can rely upon the agreements you made with your co-parent and you can stop paying support or financial obligations. Another option, if you can't agree, is to get the court involved. You'd then be in the position of filing an application to ask the court to emancipate your child. You'd have to provide a lot of proofs, including why your child is outside the sphere of influence, why you believe that emancipation is necessary, and why you think that your obligation to provide financial support, health insurance, or other remedies should be ended. The court then has a few options. It can dismiss your application if it finds you haven't met the burden of proof to even start the conversation about whether your child is emancipated. Or the court could do the exact opposite. It could decide you met your burden, you provided proofs, and it can enter an order emancipating your child and terminating your financial obligation. The court also has a third option. It can say, yeah, we think that you met the burden, but we're not 100% sure based on the facts whether your child is emancipated or not, so we're going to order a plenary hearing. A plenary hearing is a mini trial, and the main issue is going to be whether or not your child is emancipated and financial obligations should stop. In that case, all throughout motion practice and all the way up to a plenary hearing, you have an opportunity to go back to that first option, which is agree with your co-parent. If you can, and you can fix a date for when your child would be emancipated and when financial obligations should stop, that may be the best option. It's important to know that while there are bright line rules regarding emancipation and the sphere of influence, there are also areas of gray. Has your child finished college and has a full-time job, but are they really able to support themselves? Are they living with you and working full-time? Does that make them emancipated? Some parents might say yes, some parents might say no. This is where it's really important to work with experienced family law attorneys like our team to help you understand the nuances of the law. We discuss your family's specific facts and find out how that fits within the law. If you think your child may be emancipated and you're worried about your co-parent just stopping paying, or you're the payor and you're wondering just when you can stop making those additional support obligation payments, we can help. We look forward to talking with you.
Welcome to County. Welcome to County Office, your ultimate guide to local government services and public records. Let's get started.
Why might someone need to request an emancipation through the Family Court Forms Office? An emancipation is a legal process that grants a minor independence from their parents or guardians. It allows the minor to make decisions typically reserved for adults. Emancipated minors can enter into contracts, make healthcare decisions, and manage their finances. They can also live independently from their parents or guardians. DEN minors may seek emancipation for various reasons, such as escaping an abusive home environment. Others might need to make important life decisions without parental consent. Some minors seek emancipation to gain financial independence and manage their own earnings. The process of emancipation involves filing a petition with the family court. The minor must demonstrate the ability to support themselves financially. They must also prove they are mature enough to handle adult responsibilities. The court will evaluate the minor's situation and make a decision based on their best interests. An emancipation does not absolve parents of all responsibilities. Parents may still be required to provide financial support in some cases. The court's primary concern is the minor's welfare and ability to live independently.
To learn more, check out these links, which you can click in the description below. And feel free to comment your questions. We're here to help. Thanks for tuning in to our video. Please like and subscribe and leave a comment below. See you in the next video.
Okay, fathers. Those were 4 excellent videos speaking and talking about emancipation of minors from their parents. And like I said, my experiences directly as a state juvenile probation officer with the state of Colorado was with the children I was supervising. 4 out of 5 of them had been in foster care for at least 10 years. And they were looking at the transitioning from the foster care system to independent living. None of the kids that I had in that emancipated, they, if I can remember correctly, I don't remember any of them having relationships with their parents at all. Their parents were in their lives, but they did not have a relationship with their biological parents at all because they had been in foster care for at least a decade. So very sad situation for most of these kids, but they were motivated because they had to, these children that I had that I was supervising, they were much older life experience wise because of what they had to experience while they were in the foster care system and just the exposure and being in the criminal justice system and being failed by many, many adults. They just had a different grind. They had a different sense of urgency. They were looking through a totally different lens as far as wanting to be emancipated, get on their own, and do their thing. I remember all four of them, they had aspirations of going to college and getting their degrees and becoming professionals. I do remember that. So they were great kids, unfortunate circumstances. Life wasn't good to them. Life screwed them over, messed them over. And they had an opportunity to be able to advocate for themselves, fight for themselves, and claim their futures. So I was all for it. And like I said, never had a problem with any of these older kids because they had a different sense of urgency and they really, really were tired of everything that they were involved in within the criminal justice system. They were tired of adults supervising them, telling them what to do, telling them how to live. So they wanted to prove to themselves, not necessarily the adults, but to themselves, that they were ready for this independent living and to transition as adults. So one of them did end up going to the military. I remember the young man. He was an awesome young man. And you just never know how their lives are going to end up once they have the opportunity to transition and make their lives better. So, okay, fathers, I have a couple more videos I want to share with you. The first one is about minors law. I have an attorney explaining what exactly is minors law. And the second video behind that is another attorney speaking about, can juveniles be interviewed under 18 years of age if they're emancipated? So two very good videos. Let me get them set up.
What is minors law?
Okay, fathers, next video.
What is minors law? Minors law is the area of the law which pertains to minors, people who are deemed under the age of majority. Before people are recognized as adults under the law, they lack many rights and responsibilities. Minors law defines minors, outlines the rights and responsibilities they do have, and establishes a framework for dealing with minors in a legal and judicial context. Many nations have laws pertaining to minors on their books. In the eyes of the law, people who are below the age of adulthood are treated as though they lack capacity. This means that minors cannot make legal decisions for themselves. This includes entering into contracts, making autonomous decisions about medical care, entering into marriages, and engaging in a variety of other activities, such as making wills, opening bank accounts, and so forth. Minors law may allow a minor to do certain things, like taking out a student loan with a cosigner, in the understanding that minors may need to engage in certain activities for personal or social reasons. In addition to lacking the legal rights of adults, minors also do not have the same legal responsibilities. Their lack of legal capacity means that they cannot be held responsible for crimes in the same way as adults, under the terms of minors law. In some regions, juveniles who commit crimes of any nature are tried and incarcerated separately. In others, minors who are in their early teens may be tried as adults if it can be demonstrated that, although they were minors, they clearly understood the potential repercussions of their actions and should bear more legal responsibility. Minors lack the legal capacity for consent, although in some nations the age of consent is below that of majority, which means that minors can potentially marry or have sexual intercourse before they are considered legal adults. Minors law also states that minors cannot be held liable for certain activities, although they can still receive citations and punishments for violation of the law, as when a teenage driver speeds and is subsequently ticketed. There may be situations in which someone who is below the age of majority needs more autonomy, as for example when a minor is going to school in a different city or is making arrangements for self-care because his or her parents lack capacity. In these situations, the minor may apply for emancipation. Emancipated minors are treated as adults in the eyes of the law, with all of the rights and responsibilities thereof, and their parents are no longer required to provide care or assistance for them.
I think they look. All right. Can you interview or interrogate a 17-year-old emancipated juvenile without their parent being present? My name is Anthony Bandiero, attorney and senior legal instructor with Blue to Gold Law Enforcement Training. So this officer is in Ohio, Idaho. It says, look, under our law, we need a guardian present to interview somebody for fish and game violations, right? Title 36. Okay, that's cool. I get that. But the other day we encountered a 17-year-old that has been emancipated, right? That means that emancipated means that this person is on their own. They're no longer have a guardian. That could be because of marriage. It could be because of a court order. It could be because of various legal mechanisms. But let's just say that this is legit. This person is considered on their own under Idaho law. How does this affect interview and interrogation? I think look, I can't give you legal advice on this, and I do not have a case on this. It's a very unique and novel issue. But I think the only reasonable answer is that you can interview them, right? It doesn't make any sense that you have this, emancipated juvenile who's now legally an adult, can enter contracts, doesn't have to, listen to their parents, right? Can enter contracts and basically do their own thing, but yet you can't interview them when they are engaged in criminal conduct. I don't think that makes sense. I don't think from a policy perspective, the courts would back that up. I would have to see the laws, but again, I'm not looking to get that deep into the weeds on this. I'm talking from a constitutional perspective. First of all, actually, I got to tell you, from a constitutional perspective, it's even less of an issue because all these laws about don't talk to juveniles unless you have an attorney present, like in California, and all these other things, all those are laws made by the legislature. They're not required by the Fifth Amendment. So the Fifth Amendment allows you to talk to 17-year-olds. So that would not be a violation here. All right. So I think you talk to them. And the worst case scenario is what? You get the confession thrown out, right? I don't think you clearly violate anybody's rights. I hope it helps. Share with your friends. Hopefully it helps. Until next time, my friends, stay safe.
Okay, fathers, 2 excellent videos talking about minors law and how it affects emancipated minors. So you heard from 2 attorneys, and like I said, all the videos that I'm sharing with you today are also in the description. Every live stream that I share, the videos are always in the description of my live streams. So just want to share those 2 videos with you. The next video that I have, fathers of daughters, the very last video, and then we're going to end this live stream. It is talking about the registration of emancipated minors regarding their medical records, and a very, very informative video when I came across it. So just wanted to share this last video with you, and it's important for businesses and to understand what their responsibilities are when they're dealing with emancipated minors, and so they don't end up in a situation that is not good because you're still dealing with juveniles. So this is an excellent video that I'm getting ready to share with you that explains some things on the medical side of being an emancipated minor. All right.
Patient has.
Okay, fathers and daughters, last video.
Hi everybody, Jennifer Blevin-Smith with Integral Clinic Solutions, and you're watching my YouTube channel, Navigating the Business of Medicine. Today I want to talk about guarantors or responsible parties when it comes to minors being seen in the practice. A lot of people may not be aware of this, but there are laws and regulations against sending minors medical bills in the mail. You cannot list a patient who is a minor, 17 and under, as the responsible party or guarantor in an account. There may be some exceptions to this, like if they're an emancipated minor, and that doesn't happen very often. When you are registering a patient, specifically a minor, it's very important that your front office or whoever is doing the registration is entering the legal guardian or parent's information where it comes to the guarantor/responsible party section of your EMR. All EMRs should have that separate section, and they should always be correct. They should always be the parent or legal guardian for minors who are patients. Now, this can get confusing because when a patient has Medicaid insurance, so they are state insured, you put the patient as the subscriber. So it's not like you put down the parent's name as the subscriber, you put down the actual patient because they all have kind of their individual policies with the state. This is different if they were insured by a commercial plan under their parent's insurance, where you would put the parents as the subscriber. So people get really confused in this situation because they will list the subscriber and the guarantor as the same person if the patient has Medicaid. But if they are a minor, it has to be different. If it's a minor with state Medicaid insurance, you put them, the individual child, as the subscriber, but the responsible party guarantor field would be their legal guardian or their parent. If the patient has commercial insurance, then the subscriber most likely is going to be the responsible party and the subscriber as well. So where it gets really confusing is with the state Medicaid insurance, but you have to make sure that you're educating your front office to know that the subscriber would still be the minor, but the responsible party who would be paying the bills and who would be responsible for any kind of financial obligations, if you will, would be still listed as the parent or the legal guardian. And you might say, hey, most Medicaid, you don't have patient responsibility, so why does it matter? Well, that's a good question. In most Medicaid plans, you're correct. They don't put patient responsibility, but there are a few out there that, might have an MCO plan where they'll have to be responsible for a certain amount out of pocket, depending on maybe it's a sliding scale type plan or something based on their income. The purpose of this is just to make sure that your front office staff is always doing it correctly. There's one way of doing it. And for all patients who are minors, you never put the patient as the responsible party or the guarantor. Then there's no ifs, ands, or buts. They know if they are registering a patient who's 17 or under and they come to the responsible party field, they know they cannot put the patient. They just get in the good habit of putting down the parent or legal guardian in that situation. And a lot of EMRs, if they're good and robust, you can connect multiple different patient accounts to the same guarantor or responsible party, which is really nice. So you might look up one patient and click on the guarantor button, and you would see who the guarantor is, but you can see all the accounts listed under that guarantor who are also patients at your clinic. So if Jennifer, I'm the responsible party, guarantor, and you click on my name in one of their accounts, you might see child A, B, and C all listed under there as well because they're seen at the practice, but I would be receiving the bills for all of them. The other thing you want to make sure is with the responsible party guarantor, sometimes the parent who insures the child is not necessarily the responsible party. It might be the other parent, and that can get really confusing, and you might get stuck in the middle of some ugly kind of custody divorce stuff. So you guys can have a policy in your practice, and I would definitely talk about this and put it in your handbook and have the policy. So if patients ask you about it, you have it readily available, that whomever is the subscriber on the insurance or whoever the parent is that brings in the patient to be seen automatically gets listed as the responsible party, and statements go to them. And it's between their own selves, their own personal issues, that they get those bills to whomever is responsible for paying those. That's not any of your business unless you have specific court orders or paperwork showing that you need to send it to a specific parent. Other than that, I would have a policy in place so that if that ever comes up, you can say, I appreciate that you're asking me to do this, but our business clinic policy is whomever brings in the patient for their first visit is the responsible party. You will be receiving statements, and then it will be your responsibility to give it to the other parent to pay. And they might get upset about that. You might have to get your manager involved, but it's good to have that policy because it can get really ugly and you put your staff in a really awkward situation. And that's honestly not our responsibility. It's not our business. That's between individual families. And as long as they are working together, then they can deal with that themselves. So make sure you have that policy in place too. But again, just remember, minors can never be the responsible party / guarantor on an account, and it needs to be a legal guardian or parent who would be paying the bills or any financial obligation. If you have any questions or comments about this, please leave that in the comments below. Smash the thumbs up button if today's video was helpful, and subscribe to my channel if you haven't already. Thank you for the support, you guys. Take care of yourself. Bye-bye.
Okay, fathers. Another live stream, fathers. Another great live stream. Appreciate you thoroughly. A little bit earlier than most days that I do my live streams. So some fathers may just be getting their kids off to school and off to work. It's all good. But I just want to share that live stream with you, fathers, and give you additional information. It's not going to affect the majority of us fathers of daughters, but there may be some fathers of daughters out there that are needing help, and families that need an understanding of emancipation of minors. So if you come across the video, subscribe, like, share. Feel free to share it with whomever it could benefit. All my videos, feel free to share them with fathers of daughters that can benefit from them. Okay, so fathers, I live stream once a week. And like I said, another successful live stream. So we'll be doing another live stream next week. And fathers, have a great week. Kiss them babies, love them babies, embrace them babies, show them that you love them. Tell them that you love them. Okay, protection and safety. It's always on our shift, fathers. All right. Okay, fathers. Until next week, this is FRB Martin. Mis amigos. Hasta la próxima semana. Gracias. Okay. This is FRB Martin. You know the routine. I'm out until next week. Peace.